Harris. Mr. Woodworth.
Thank you very much, Mr. Chair. Ladies and gentlemen, I think that the issue here is whether or not you are satisfied or dissatisfied with what the increase in illegal drug trade has done to the youth of our country, has done to our country. Or to put it another way, are you going to stick your head in the sand and do nothing but more of the same? Or are you going to mangle Shakespeare a bit, take up arms against a sea of troubles, and at least try to find a solution? This is a sad debate to have, but it is where we are at. And I have to tell you, one of the biggest surprises to me, sitting as a member of this Justice Committee over the last 3 years, has been to sit and listen to respected academics come to committee and actually say that they recommend that all illegal drugs, from marijuana through cocaine to heroin to Rohypnol, should no longer be criminalized. This is one academic opinion. And I won't bore you with the reasons, but they have their reasons. I suggest to you that this is simply not in touch with what's going on in our country. And I know one of the other members provided this quote earlier, but I would like you to contrast that academic opinion with the opinion of someone who's on the street. Mr. Chuck Doucette, the Vice President of the Drug Prevention Network of Canada. And I'm going to repeat this because I think it contrasts with the academic opinion that I've just mentioned to you. Things have changed from when I first started in drug enforcement in 1977. Over those 30 years, I saw the sentences for drug offenses getting progressively weaker. At the same time, I saw the problems related to drug abuse getting progressively larger. I also saw the drug scene in downtown Vancouver increase as the enforcement efforts in that area decreased. From my perspective, I do not see how anyone could possibly examine the past 30 years and make a case that weaker sentences lead to less damaging social consequences. My experience is that the more lenient we got, the more problems we got. Now, I ask you, does that not strike a chord? Does that not ring truer to what we really all know about what's happened with respect to sentencing and drug offenses in Canada? Is that not a more realistic sentiment than the academic notion I mentioned to you earlier of some academics who simply want to legalize all drugs? I want to comment a little bit on the issue of deterrence, because once again, I have sat here and I have listened to academics come to this committee and virtually say, and I don't want to paraphrase too much, but virtually say that there is no point in deterrence sentencing. Now, this rather surprises me because I'm only 3 or 4 or 5 years away from the practice of law, and I can tell you that to say that deterrence sentencing is practically of no value is simply out of touch with what is going on across our country. Every day, in every major city in Canada, in every courtroom, there are judges who pass deterrence sentences. Are they all wrong? Every day in every major city and every courtroom across Canada, there are prosecutors who are advocating for deterrent sentences. Can they all be wrong? Are all the police who ask for deterrent sentences wrong? Are all of the parents who actually often plead with the court to impose deterrent sentences on their children, are they wrong? are all the victims who have come to this committee asking for deterrent sentences wrong. I have to tell you, and I swung both ways. I was a defense counsel and a prosecutor for many years. Most of my defense counsel friends recognize that deterrent sentences are often required in order to stop the revolving door syndrome of people going in and out of jail. In fact, I'm not a big fan of jail, especially when it comes to younger people. I'm happy that this act, along with the previous Youth Criminal Justice Act, indicates to judges that jail should be a last resort for young people. But I have to tell you, we had a witness here a couple of years ago, a young man in his 20s, who said, you know, he got a lot of little sentences and it didn't faze him at all. Finally, he got a 3-year sentence. He was able to take some treatment programs to bring some stability into his life, and he came out a much better man. He was grateful. Not every jail sentence has all of the terrible consequences that the NDP members would like you to believe. I want to relate a judge in my community, I guess I can name her, Justice Hardman, a youth court judge, and every time someone came before her in relation to an assault offense, she made a point of telling them that if the assault occurred at a school where children are required to be, where they're captive, where they are defenseless, she would impose a prison sentence. Now, why do you suppose she said that? She said it so that she would be deterring other young people from committing assaults at school. And you know what? It seemed to work. She thought it worked. I thought it worked. Now, you could call that anecdotal evidence, or you can just call that good, ordinary sense based on years and years of first-hand legal practice. Maybe it doesn't measure up to a textbook, but it works. I want to say one last thing about the issue of deterrence. This bill that we're looking at here is targeted largely at organized drug crimes. And we did a study on the Justice Committee. Some of the members weren't here for it that are here today, but we did that in the last year or two. And you know what we discovered? Oddly enough, ironically enough, organized crime is run by organized criminals. And you know what? Organized criminals are the ones who determine their actions based on their pocketbook. The more expensive it is, the higher price they pay, the less likely they are to do it. The more effective deterrent is when it comes to organized crime. I wish to comment briefly on the issue of judicial discretion because, in point of fact, the NDP always supports judicial discretion when it permits a judge to be more lenient. But we've seen just in the last few days that when we try to pass a law which gives the discretion to judges to maybe exercise a little deterrence, to permit custody or more consequential remedies, where are the NDP principles in favor of judicial discretion? They evaporate like the wind. And you know what? There's a place for judicial discretion. There's a place also for removing judicial discretion. But I tell you, if you're going to fix your hat, hang your hat on the notion that it's good to give judges discretion, then there's absolutely no reason to deny judges discretion to impose more consequential remedies, as well as more lenient remedies. And I noticed, by the way, that this same inconsistency appeared every time the Canadian Bar Association representatives came to our committee. A brief word is necessary about the rather misleading comparisons that the NDP members often make between what this government is doing and what occurs in the United States. And much hay was made in the media recently about Texas adopting a more lenient approach to sentencing and warning Canada not to go down that path of being less lenient. Well, my friends, it's necessary for you to know that even the more lenient sentencing rules that Texas is adopting still result in an incarceration rate 5 times greater than anything that you see in Canada. And you know what? Nothing this government has proposed comes anywhere close to the 10-year mandatory minimum penalties that are imposed in some U.S. jurisdictions. Nothing that this government has proposed comes anywhere close to the infamous 3 strikes and you're in jail for minor puny little offenses. That's not even rumored anywhere in this government. It's not going to happen. The comparison is completely untoward. Instead, what we have are carefully targeted penalties at the worst offenses or the worst offenders. In fact, you know what? If you actually read this bill, you're going to be surprised by some of the things you see in it. For example, if someone is convicted of trafficking in cannabis without any aggravating features, they haven't produced it, they haven't gotten children under 18 involved, they're not doing it near a school, just simply trafficking in cannabis, you know how much they can traffic without any mandatory minimum penalty? And this you will find, by the way, in what will become under this Act, Section 5, subsection 3, paragraph A.1, 3 kilograms. Now, I'm regrettably still a pounds and ounces type of guy, but it seems to me that 3 kilograms of anything is a good whack. And under this bill, you can traffic 3 kilograms of cannabis. And if that's all you're doing is trafficking it, you're not producing it or invoking any of the other aggravating circumstances, there is no mandatory minimum penalty. That's how non-draconian this bill is. I want to mention 1 or 2 other sections that are of interest in this respect, and Mr. Chair, I'm simply relating them to the comments about Section 39, but I want to jump ahead a little bit. You'll find that this Act will insert a new paragraph 9 into the Controlled Drug and Substances Act. And you know what it requires? It says that within 5 years after this section comes into force, a comprehensive review of the provisions and operations of this Act, including a cost-benefit analysis of mandatory minimum sentences, shall be undertaken by any committee of the Senate or the House or of both that may be designated. In other words, ladies and gentlemen, this Act, Bill C-10, has built into it a 5-year review which will tell us what the cost benefits of mandatory minimum penalties are. So why don't we give it a chance for those carefully targeted instances that I'm going to refer to in a moment? One other provision which is of some interest in showing you just how moderate and balanced Bill C-10 is what will become Section 10, paragraphs 4 and 5 of the Controlled Drug and Substances Act. And you know what this section says, and it's not mentioned by my opposition friends, or perhaps they mentioned it when I wasn't listening earlier, but it says that, in fact, the mandatory minimum penalties under this part that we're discussing are not going to be required if the offender attends a treatment program and successfully completes it. So when you hear the NDP talk about these drug addicts who are going to be thrown in jail because they're lower-level participants in the drug trade and happen to get caught up using a weapon or assaulting somebody, the reality is that those folks, if they successfully complete a drug treatment program, will not be subject to any mandatory minimum penalty under this Act. That is how moderate and balanced this Act is. Now, I truly recommend to anyone that they read the Act because what you will find is that it is targeted. So I ask my NDP colleagues, if you found that someone was trafficking drugs for the benefit of an organized crime group, would you think that perhaps maybe they ought to go to jail to put a dent in organized crime? That's one of the aggravating features that does require a mandatory minimum penalty in this Act. But is it so terrible for the government to want to try to put a dent in organized crime? I don't think so, and I don't think most Canadians believe that either. I think that the NDP and others who argue that we should not try to put a dent in organized crime in this fashion are out of touch with what's required in Canadian society today. But if that's not enough, if it's not enough that a drug trafficker is working for organized crime, would it be enough for you that the drug trafficker used violence in the commission of his offense? Would that be enough to suggest maybe a jail sentence was warranted? Well, I see Mr. Harris shaking his head. Yes, that happens to be the second aggravating feature in this Act, which would invoke a one-year mandatory minimum penalty. But if that's not enough, if it's not enough that violence is used, would it be enough that somebody used a weapon in the commission of their drug trafficking? You know, we have a great concern about weapons offenses and drug gun offenses in this country. Surely, if someone uses a weapon in the course of trafficking drugs, that ought to justify a mandatory minimum penalty. And indeed, that is another one of the aggravating features which will allow a mandatory minimum penalty of 1 year. And in this regard, I don't often quote from the Toronto Star, but I do want to just mention an article that did a rather in-depth study of Young Offenders Court. It appeared October 29th, 30th, and 31st of this year in the Toronto Star. And with respect to weapons, at least, and also I'm going to come back to this point with respect to the use of young people in drug offenses by organized criminals, but in particular with respect to drugs, it was stated that so many are arrested, charged, and convicted of carrying, pointing, and shooting guns. And this is, by the way, in Young Offenders Court, prosecutors call the problem a scourge. A scourge. And they're right. Young people should not be using weapons, using guns, pointing them, threatening them. A justice of the peace is quoted as saying, and this is in Toronto, by the way, "Our city is plagued with guns that exist in the hands of young people." So maybe a mandatory minimum penalty to deter the use of guns and weapons isn't such a bad idea. Or if that's not enough to justify a jail sentence, would it be enough that a drug trafficker is hanging out at your daughter or your son's school, or at the skating rink where young people are accustomed to go, or any other place where young people are accustomed to go, in order to lure young people into the use of drugs? Would that be enough, I ask my friends across the way, to justify a deterrent mandatory minimum penalty? Because that's another aggravating feature which under this Act would. I'm going to mention one more. If that's not enough, that drug traffickers are out where children congregate, luring them to purchase drugs, would it be enough for you if a drug trafficker actually enlisted someone under the age of 18 to sell drugs for him or her? Would that be enough to justify giving that trafficker a jail sentence? Just before you answer that, I want to quote again from that Toronto Star article. and I'm not going to mention names, but there are 3 examples of 3 young people that were referred to in that article. One of them was convicted of marijuana possession after a car he was riding in was pulled over and also found to contain hundreds of dollars in cash, half an ounce of crack, and a gun holster jury-rigged from a coat hanger. This is a young person engaged in the drug trade. Another one was convicted of attempted break-and-enter and marijuana possession in April, then rearrested in June after police allegedly found 2 starter's pistols in his bedroom and more than a gram of narcotics up his rectum. A third one is referred to as one of the many crack dealers, a 16-year-old, one of the many crack dealers to come through the youth court in 2011. There is no question that organized criminals are recruiting young people to traffic drugs because, you know what, we have to treat young people differently when we sentence them. They don't get penalized as heavily as if they were adults. So why not, if we know that an organized criminal has recruited a young person, surely that's enough to justify putting that drug trafficker in jail. And that, my friends, is another aggravating feature, which is one of the instances to invoke a mandatory minimum penalty under this Act. And I could go on, but I think you get the drift, ladies and gentlemen, that this Act is targeting specifically aggravating features and specifically aggravating offenders in an effort to do something about a real scourge in our community. And that is simply a recognition that our government is in touch with police, is in touch with parents, is in touch with courts and prosecutors, and attempting to respond to a problem in a way that, unfortunately, for ideological or other reasons, you will never see from the NDP. I perhaps will have an opportunity to speak later about the other provisions of this bill, but I appreciate this opportunity to express myself, Mr. Chair. Thank you.
Thank you. Mr. Jacob.